Hello, and thank you for joining us for part 4 of our 4-part Intellectual Property Basics series. This workshop series is being presented through a collaborative partnership between the Arkansas Small Business and Technology Development Center and the UA Little Rock William H. Bowen School of Law Business Innovations Clinic. I'm Brett Harris, a Rule 15 student attorney at the Bowen School of Law.
And I'm Kim Vu Din, an assistant professor and director of the Business Innovations Clinic at the Bowen School of Law.
The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials shared in this presentation are for general informational purposes only. Information presented in this presentation may not constitute the most up-to-date legal or other information. This presentation contains links to third-party websites and materials. Such links are only for the convenience of the attendee, user, or observer. UA Little Rock does not endorse the content of third-party sites.
In today's presentation, we'll discuss the definition of a patent, what is needed to qualify for patent protection, and then an overview of the patent application process. And finally, we'll conclude with a look at a trade secret protection.
To recap, patents and trade secrets are two of 4 major legal tools commonly used in intellectual property. For more information about copyrights and trademarks, please review our other presentations on each of these topics.
Let's start things off with a pop quiz. True or false? Patents are the only way to protect the design and shape of product packaging. False. A trademark can also protect trade dress. In fact, trademarks are often preferred over design patents because trademarks can last much longer than the 20-year patent protection.
So what exactly is a patent? Well, a patent is a property right issued by the United States Patent and Trademark Office, USPTO, to inventors of ideas or developments. A patent gives the owner an exclusive right to manufacture, market, and distribute the invention for sale or for free. This exclusive right is typically granted for a period of 20 years from the date of application.
So now let's start by taking a look at the general requirements needed for an invention to qualify for patent protection. First, patents must be new and useful inventions and processes in order to qualify for registration. Useful means that the invention or process is operational and produces a beneficial output. New means it has not yet been patented or otherwise been used in the world publicly with or without a patent. With respect to being new, it is important to note that once you file a patent application for an invention, that invention is no longer new because it has been disclosed to public record. This is particularly important because a single mistake on a patent application can cause an application to get rejected. Thus, if an application has been rejected, you cannot file another application for the same invention unless you do so less than a year from when the first one was filed.
So what types of things generally can be patented? There are generally 5 distinct categories of patentable subject matter, which are machines, processes, compositions of matter, newly created species of plants, and designs of useful inventions.
In addition to being new and useful, an invention must also be novel, serve a utilitarian purpose, and be non-obvious. Now let's look closer at what each of these mean.
Let's start with novelty. Novelty, as used in patent law, means that the subject matter cannot be shown in a single prior art reference. So what does prior art mean? The term prior art refers to any evidence that the work is already known prior to the date of filing the patent registration. Some examples of prior art include patents of the same work and also mere patent applications, descriptions in printed publications, inventions used by the public, and inventions sold to the public. Here, it is important to note that experimental use of a work is generally not considered a prior art. However, commercial sales are considered prior art, meaning that the work would no longer be novel if it was to be sold before the patent application was made.
Before we move on from novelty, let's discuss what a disclosure is and why it's important to understand what it is. As used in patent law, a disclosure is the public sharing of information about an invention. Disclosures include activities such as advertising and, as previously mentioned, selling the invention. The most important thing to remember about disclosures is that patent applications themselves become public record upon filing and are considered disclosures. We cannot emphasize enough that this is very, very important to remember, because a mistake on a patent application could bar the invention from qualifying for patent registration altogether. There's an exception to this rule, of course. Disclosures made 1 year or less from the date of patent application filing are not classified as prior art or disclosures. So, if you started selling your invention, you have 1 year from the time of the first sale to start the patent application.
Now let's move on to the utility requirement. Here, utility just means that the machine, composition of matter, or process must actually function and produce a legitimate legal benefit.
Last, let's take a look at the meaning of non-obviousness. This can actually become pretty complex, but the definition states that something non-obvious means that an average person working within the industry or field that the invention would be useful in would not readily see the obviousness of the invention. Here you can almost think of this as the invention must not be something that other people can readily conceive as being useful to achieve a particular benefit.
Now let's take a quick break for a pop quiz. True or false? You cannot obtain a patent if any public disclosure of the invention has been made. If you said false, you are correct, because as stated earlier, there is a 1-year grace period after the date of first disclosure in which a patent application could still be filed.
Now let's take a high-level look at the steps leading up to filing a patent application. As you can see, this process is very complex and consists of several steps. First, you must ensure your invention is new, meaning that nobody else has created your invention prior to you. A good starting point for this step is to conduct a search at paft.uspto.gov. You can also utilize patents.google.com to ensure your invention is new. However, it's recommended that you always follow up with the search of the official USPTO database. Second, you need to determine the type of patent application you'll be filing. Third, you need to decide if you need international protection or expedited examination. Fourth, you need to decide whether you'll seek assistance from a patent attorney or a patent agent, or proceed without counsel, which is called pro se. Here, we cannot recommend strongly enough that you seek the assistance of a patent attorney or agent because of the complexity of the process and the implications a single mistake can have on patentability. Fifth, you need to prepare for filing, which includes drafting renderings and detailed descriptions following the USPTO's very stringent guidelines. Last, you are now ready to file your application. From the time of filing, it takes on average about 22 months for the USPTO to examine and make a final determination of the application.
There are 3 patent type applications you can pursue. Utility patents, which protect new or improved useful processes, inventions of machines, or composition of matter. utility patent applications are by far the most common patent type granted. Design patents protect the underlying design of manufactured goods. It is important to note that something eligible for design patent protection might also be eligible for trademark protection, which could be better since it lasts longer. Last, plant patents protect new and distinct varieties of plants. Keep in mind, you cannot get a plant patent for a discovery of an existing plant.
So, do you need to hire a patent attorney? Absolutely. Patents are very, very complex. There's a lot of room to make mistakes. As we said earlier, a single mistake is fatal to an application forever. We cannot recommend strongly enough that you seek assistance in obtaining a patent from a patent attorney or a patent agent. Remember that patent applications become a public record and count as a prior disclosure. Also remember that after 1 year elapses from a public disclosure, you cannot obtain a patent protection.
To give you an idea of the complexity of patent applications, look at these actual design patent and utility patent applications. The design patent application on the left is for the design of an Apple laptop. The utility patent to the right is for an aircraft. As you can see, both require precise drawings or renderings of the invention and require detailed explanations of each feature and how the features work together to make the invention function. Note that these are just the cover pages to multi-page applications.
Because the process of preparing a patent application is so difficult and complex, the overall cost of obtaining a patent is significantly more expensive than obtaining trademark or copyright registration. With the assistance of an attorney, you can expect to pay anywhere from $5,000 to $10,000 for a patent, and this can easily be higher depending on the overall complexity, your geographical location, and the amount of experience the attorney has. Patents are granted generally for a 20-year term from the date of filing of the application for protection. After the 20-year term expires, anybody is free to copy, produce, and sell the invention with no compensation to the former patent holder.
It's time for another pop quiz. True or false? Patents are the only way to protect a secret recipe.
False. If the recipe is not easily reverse engineered and has economic value, it may be a good candidate for trade secret protection. It's important to note here that a secret recipe might also qualify for patent protection. However, patent protection might not be the best form of protection due to the limited duration of protection.
Now it's time to talk about trade secrets. We've already alluded to the importance of whether an invention can be easily reverse engineered or not. Let's talk about why that determination is so important. As you may recall, patents are typically granted for 20 years from the date of application. It is not uncommon for the patent process to take 2 years from the time of application. Therefore, patents protect inventions for a rather short period of time, after which anybody can use the invention for any purpose without compensation to the patent owner. This is the very reason why inventions that are not easily reverse engineered should strongly consider trade secret protection instead of patent protection. To a certain extent, trade secret protection is perpetual so long as secrecy is maintained. This is how the recipes to Coca-Cola and Kentucky Fried Chicken are still secret.
So, how do you keep a trade secret secret? Generally, you must take reasonable measures to protect the secrecy of information and the characteristics of the information. Additionally, the information being kept secret cannot be publicly known, and they must have economic value. Because trade secrets cannot be disclosed, no registration is required for protection.
So if information has to remain a secret, how can a business use the information or benefit from it? The answer to this is that simply keeping the secret to yourself is not the only way of maintaining secrecy. Businesses commonly use non-disclosure agreements, or NDAs, to protect information from being released. An NDA is a contract that lays out the type of information to be shared between the parties in an agreement and what specific uses of the information are permissible. Employees, vendors, and any other third parties who need to know trade secret information should be required to sign an NDA. Some additional common tools to ensure secrecy include labeling confidential information as confidential and frequent employee training on the handling of confidential information. Additionally, businesses should be cognizant of how they dispose of materials containing confidential information so as to avoid inadvertent public disclosure. All of these procedures, when applicable, should be undertaken in some form or fashion to protect the secret.
It seems rather obvious that secrecy of trade secrets is critical. However, far too often, mistakes are made and trade secrets are inadvertently disclosed. Because of this, you should never file a patent application with the intention of using trade secrets as a safety net if the patent registration is denied. This again is because patent applications become public record. Similarly, you should closely examine your business operations to ensure that you're not sharing or accidentally leaking out too much information with the public, vendors, or customers.
What does it mean that the information must have economic value? Having economic value means that the information itself would be valuable in the hands of another party, or that the information gives a competitive advantage to its owner. Courts generally determine the economic value of information by examining the following factors: significance to the business of the owner, development costs, protection costs, licensing value, and misappropriation value, which is essentially how valuable the information would be if obtained by another party.
Trade secrets are protectable so long as the information is not publicly disclosed, appropriate security measures are in place, and the information retains economic value. The total costs of trade secret protections are entirely dependent on the steps and measures implemented to maintain secrecy of the information. However, generally, you can expect to pay an attorney anywhere from $250 to $500 to prepare a non-disclosure agreement.
It's time for one last pop quiz. True or false? You can sell products that are manufactured using company trade secrets without losing trade secret protection. True, so long as the trade secrets do not become publicly known and retain economic value. Again, the key is that trade secrets cannot be easily reverse engineered. Again, think of the Coca-Cola recipe. The drink is made from that recipe and sold worldwide, but the company has managed to limit the amount of people who know the actual recipe and have taken extensive steps to ensure the recipe is never disclosed.
We've covered a lot of material throughout this presentation, so now let's end things by taking a look at some of the important takeaways. First, the process of filing for patent registration is extremely complex. Second, prior to filing for patent registration, you should always consider if a patent is the best form of protection for your IP. That leads us to our last takeaway, that trade secrets are particularly useful for things that cannot be reverse engineered easily. Consider them first if you want protection for something that can't be reverse engineered.
For more in-depth information on each of these tools, check out our other toolkits on our websites. You can also visit copyright.gov and uspto.gov. For more information about ASBTDC or the Business Innovations Clinic, please visit our respective websites at the addresses shown here. We hope you have enjoyed this presentation.